It's always a big challenge, right, to invite lawyers to speak in events like this, especially when you use words like scams. Do you miss something? No? And it is actually a big challenge, and I can prove this to you as a lawyer, because not a single man, not a single lawyer actually, in the world ever claimed that he drafted or she drafted a smart contract. And programmers and ITs claim, and most probably they did, produce smart contracts, all right? So the world is changing, and in addition to this, if you visited a lawyer 2 or 3 years ago, trying to explain what is cryptocurrency, what is ICO, what you try to do, what is your idea, and how he can structure your idea in a legal way, most likely you get the answer that this is illegal, you go to jail, but we have a very good criminal department in our law office. So this is the story how it was at least some years ago, but fortunately, we start learning as lawyers, all right? And we actually start looking on how we can fit this new technology, blockchain, cryptocurrencies, how we can fit this in the existing regulatory framework, or at least try and make a new one, which is not an easy task, obviously, but definitely it is something that it will dominate the discussions in the coming years, and already dominate a large part of the discussion. Today, we're going to go through the ICO industry, because obviously, in order to understand how to regulate something like this, you need to understand what are the needs of this industry, what are the factors driving this growth of ICO industry. Obviously, what are the risk warnings in this industry, and try to define the legal areas that need to be addressed, need to be tackled in some way if you want to be legitimate. Okay. In a very simplistic way, don't expect from a lawyer to be very technical on this, but what is an ICO? Obviously, it is a form of crowdfunding, similar to what is IPO, initial public offerings, but without trading securities or claiming not to trade securities, but trading coins or tokens. So just to make clear, because we're going to use this word later on, actually, although it is called as initial coin offerings, the word coin, actually we're talking about tokens. So you may find this also as initial token offering. And how it works, yeah, smart contracts, here it is. Basically, you sell your own token. Someone pays for that. He receives the token, your token, in his digital wallet. You can pay either by using other cryptos or even fiat currencies. The project is always linked to an innovative project, because you need to attract the interest of the buyers to pay you get money. So you present to them what is your idea, usually by using a white paper. It's like a prospectus that you upload on the website, and you explain what you're going to do with the money that you will collect from the buyers. And once the sale of the tokens is completed, then the token enters the secondary market. It's being part of the exchange platforms, and you can even win or lose your money by the increasing or decreasing value of this token. This is more or less the situation with ICOs. Obviously, everything depends on the marketing, because already there are so many ICOs around, and a good way to attract the interest of the people is, apart from the white paper, it has to do with the advisors that you put on your website, and the people that actually behind all this in this project. In terms of numbers, 2016, very poor year. It was still in the beginning, around 100 million capital raised. 2017, 210 ICOs roughly around the world, capital raised 3 billion, and just not even the half of 2018, we have almost reached the number. It's around $2 billion US dollars. Of course, a very key role in this increase in 2018 was because of Telegram, that they raised, already in the pre-sales more than actually 1 billion. Now, as I told you before, what we need to understand, first of all, before we come into regulation, is what is the driving force of the need of people that they run their ICO projects and people that they buy these tokens from the various ICOs. First of all, and this is the first and maybe the most important factor, is that we are always talking about startup companies. You know how difficult it is for startup companies to raise funding. And actually, by using this technology, you give to yourself the ability to reach people across all over the world, and you can raise funds in a much easier way than approaching a couple of investors and trying to convince them to give you a lot more money. You are looking to thousands of people paying you smaller amounts than 2, 3 very wealthy people giving you a lot of money. Obviously, another factor is the massive increase in the value of cryptocurrencies. Okay, this is something that, as we're going to see later on, it depends on the volatility of the cryptocurrencies, but still, the value, the experience we had by the end of 2017 showed that this helped a lot to increase the numbers of ICOs. And the decrease of the value of cryptocurrencies is a factor that affected significantly new ICOs coming into the industry, and the majority of them actually postponed their ICOs until cryptocurrency, Ethereum, Bitcoins go up. The power momentum, Angelos before said something very, which is absolutely correct, that you don't even need to know what is blockchain. Now there is a kind of, a myth around blockchain that this is something good, this is something that everybody invests, this is the future, so yeah, it must be something good as well. So the momentum of blockchain technology is a critical factor as well for the increase of ICOs. Another one, a fourth factor, is the incredible returns, particularly to early buyers. Okay, this is something that is not the case always, obviously, but when you listen to people that they got rich very easily just by buying a token or coins or whatever, this is something that drives, the interest of other people to go and establish ICO and sell their ideas out there and collect money at the end of the day. Of course, this is what we heard. What you heard so far is the good part of the story, and always there is the bad as well. And I'm talking about the risks warnings about ICOs. We are talking, as I told you before, about startup companies basically, and it is true that throughout the years, it's traditionally, let's say, startup companies, 90–95% of them simply collapse. So we are talking about this, we are still looking for this maximum 5% of these new startups, these startup companies, that will make the difference and worth our investment. Now, volatility is always an issue here. Fraud, hacks, malwares, all these software and computer issues are always there because we are talking about digital technology. We have already experienced a number of ICOs that they proved to be scams. So Nick was right that already ICOs have been associated with scammers, and this is something that obviously regulation needs to address, and regulation needs to reboost the confidence of the public if we want this industry survive. And apparently, when you listen about great numbers, some millions, that everybody's going to be rich, and stories like this, always bear in mind that whatever sounds too good, most likely is not so good to be true. Now, okay, in this kind of this environment and all these good and bad things, risks, warnings, and all this stuff, the first thing that comes into our mind is, first of all, what kind of regulation we need, so where we need to focus on, and secondly, how easy is to control technology, because it is like a tradition, standard issue for us as lawyers, that law is always coming second. So you have the technology, you have people developing, people producing ideas, and then somehow the regulator, the legislator comes and says that, okay, this needs to be controlled, so let's put some regulations, let's put some rules. But where? First of all, bear in mind that when it comes to set up, to establish an ICO, let's say that you have a brilliant idea, you have the right people, you have your advisors, you have a very great potential to succeed, and when you visit your lawyer, you need to start thinking in a different way. And what I mean is that, first of all, you need to think about the right jurisdiction. This is number one issue in ICOs. I'm sure that you all listened already about some exotic jurisdictions, some offshore companies that actually run ICOs, that they try to build a corporate structure which is clearly a corporate structure that you try to escape from the various traps or the regulators across the world, because it's not only issue and sell tokens or coins, it's also the story after that. How you can trade, which exchanges, how you can transfer crypto into fiat, what about the banks, what about the lawsuits that most likely you're going to face, things like that, it's a very, very difficult and demanding exercise for the lawyers to try and answer and predict in some way all these likely events in every single ICO. I put here some basic questions that we always need to address when it comes to decide about not only the jurisdiction, but also the content of the ICO, and how to make sure that the initiator of the ICO will actually benefit in the end of the day, and not just receiving the lawsuits. So, first of all, what is the liability of the token issuer or seller here? Okay, I'm selling you something that it's, in most of the cases, it doesn't exist, right? I'm selling you an idea that I want your money to help me to develop something that I believe it is good, and I convince you as a buyer that, yeah, you are right, this might be good, but I'm not so sure, so I'm not giving you much money. I'm giving you some of my money because I always want to play safe and give also to somebody else. Right, okay. Then, what, as a buyer of this token, what is my position against you? Am I have any rights? Or I just bought something which is obviously digital, never gonna see this, but it has a kind of value, and at some point I can trade this with you, the seller, or somebody else. Now, here is where we start discussing whether the token is a currency, it's an asset, equity, debt, derivative, donation, whatever. You can put any single word that may fit in your mind that this token is in your ICO. But this is not the critical test. It's not you that you're going to decide how you can name your token or your coin. It is, we just try to create, let's say, a project in a holistic way, all right, that it will give when the time comes when the regulator going to visit your office, try to present a number of things proving that this is your case. So what I want to say, what I try to say to you now is that it is not a matter of how I can name my token, and if I name this being a security or as a share, for example, or as a future or as a currency or whatever. It is a matter of facts of your case, and it is up to convincing the regulator that you are in or out the scope of the regulation. But another complex issue when it comes to the legal part is that you cannot claim to have your feet in more than a pair of shoes, because what happens here is that you need to have a consistent presentation of your project. So if, for example, I'm going to claim that I'm selling a security, so I'm selling a token that I'm giving you at the same time. When you buy the token, I'm giving you some ownership rights, some voting rights. So then what other things that I should consider for compliance purposes in order to fit entirely into the specific regulatory framework. If I'm going to apply the security law framework, for example, there are a number of very, very strict regulations that you have to bear in mind in terms of marketing restrictions, for example, the number of investors, the way you approach your investors, they must be well-informed investors, a number of questions. Then it comes to the taxation. Most likely this is among the top 3 issues that you need to address and you need to think when it comes to ICO. What's the taxation? How you tax your token? How you tax your crypto? Obviously, it is a matter of capital gain. Yeah, true. What about VAT? When you claim that you have, for example, let me put it that way, a lot of ICO initiators, let's say, try to escape security, payment, characterization of their projects because this is something that demands a lot of compliance requirements, and they try and they prefer to use the word utility. Okay, utility, it is an option, but if you trade something that you claim to be utility, then you have to pay VAT. You have to when you buy this utility, you have to charge VAT. And another major thing is the banking system. I can tell you from my experience that when a transaction comes into the compliance department of, I'm not saying all banks in the world, but the overwhelming majority of the banks in the world, the compliance department, they are looking to find any direct or indirect connection with the cryptocurrency industry. And if they find something, it is a red flag. We have many transactions that have been blocked, not necessarily as a product, as an outcome of a transaction involving cryptocurrencies or buying tokens and all this, but just having people or entities associated in some way with ICOs, this was enough for the banks to block the transactions. So in the end of the day, when you start structuring your project, maybe it's you understand now how important it is to try and be sure from the beginning until the end how you can, what's going to be the flow of funds, what's going to be the compliance requirements, have everything in place in order to avoid shocks in the end of the day. I put here some of the already well-known cases, predominantly from the US, in regards to ICOs. We have the very first, back in 2017, from the US Security and Exchange Commission, the case of DAO, $150 million ICO. These guys here, actually, they faced the first shock when they, in their attempt to attract investors by selling their tokens in return of some voting rights, and this is what they describe in their white paper, they faced immediately SEC, in the US SEC, saying that regardless whether the issuing entity is a traditional company or a decentralized autonomous organization, this is how they call this ICO, and regardless whether those securities are purchased using US dollars or virtual currencies, and regardless whether they are distributed in certificate form or through distributed ledger technology, the federal securities law may still apply. So you cannot escape the law by simply using this kind of technology and using terms that until recently were totally infamous in the legal terminology. DAO was a case that reached the US SEC. The next one, Tezos case, it's a case that reached the courts in California. What happened here is that unexpectedly, Tezos was a huge success because they managed to raise 232 million. That was more than what they were expecting. And you can understand that all these people that bought Tezos tokens, immediately they found interesting, or let's say as a more profitable for them, to claim that they bought something which was security. And that's why they filed a lawsuit against Tezos. They managed to get a freezing order from the court there. That's why they stopped for more than a year doing the Tezos, in doing anything with the money they collected, because, and still it's a pending case, because the question there is whether there was any kind of misrepresentation from Tezos to those buyers in terms of selling them unregistered securities, and that's why they committed securities fraud, false advertising, and unfair competition. Okay, this is what they claim, and we all wait to see what's going to be the end of the story here. Now, leaving the US and moving to Europe and also Canada, the situation here is that, speaking for European Union and ESMA, the European Securities and Markets Authority, the situation here in Europe is that the regulators are still working on the kind of legislation that they will introduce for discussions in the European Parliament, first of all, and later on in the national parliaments as well, and how they try to find how they can deal with all this booming in ICOs. So far, ESMA just issues warnings to investors, to consumers, generally to everybody, that this is ICOs are vulnerable to fraud, illicit activities because of the anonymity and the volatility and all this stuff. So it's a matter of warning so far. The same applies in the UK. Now, the situation is more clear and complicated at the same time in China and South Korea, because in those countries, in China and South Korea, there has been a total ban since September 2017. But if you visit the web, you're going to see that already they began drafting the next day and how they can bring ICOs back, but in a regulated way. Thank you. I don't know if we can take any questions now, if we have the time, or okay, you decide.
Hi, so what's your opinion about self-regulated organizations that are trying to provide some kind of proprietary oversight when it comes to their regulatory approach in issuing an ICO?
Very interesting question. I heard that question, similar question in the past, and my first reaction it was that when you say self-regulatory organizations, what do you actually mean?
So an SRO, okay, so basically an organization that's made up of people from all walks of life that are getting together for the purpose of creating a framework that they can all agree on, that they think that adheres to industry standards, that even certain regulatory bodies would acknowledge?
That would be ideal, but I believe that we are very far from reaching that point where we can convince the regulators, the lobby of the banks, all these very, very solid organizations to waive any of their power in the system. So hopefully we're going to change the world, but I don't see any light at the moment in terms of self-regulation.
Okay, thank you.